My client brought a lawsuit against her doctor claiming that he was careless, causing her significant harm and injury. And now, during the time that she's questioned in a pretrial deposition, she's asked how much money she earns each year. And my client refuses to answer that question. You want to know what happens then? Come join me in this walk through the neighborhood to explain what happens when my client refuses to answer the defense lawyer's question about how much money she earns each and every year. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, my client brought a medical malpractice lawsuit against her doctor. She claims that her doctor was careless and violated the basic standards of medical care, causing her significant harm and injury. And as part of her lawsuit, she is claiming that she lost significant earnings. And because of her injury, she is no longer able to work in the capacity that she was working before. Those are all valid damages claims that we can now justify by showing that because she can't work, she lost X number of dollars each and every year. All right, during the course of her lawsuit, the defense attorney will have an opportunity to go ahead and to question her, to learn from her exactly what happened, to learn from her about what she can and can't do anymore. And now her deposition day finally arrives. This takes place in our office, in our conference room, and you should know something. There's no judge there and there's no jury there. Instead, there's a court stenographer there to record all of the attorney's questions and all of my client's answers. Now, during the course of the questioning, the defense attorney comes to the point where now she's asking about damages. What injuries have you suffered as a result of this doctor's carelessness? And my client begins to detail and explain to the attorney exactly how these injuries have affected her, exactly what injuries she has, and those activities she can no longer do or do with difficulty. Great. Now the attorney continues on by saying, hey, how much were you earning at the time of this incident? And my client turns to the attorney and says, I'm not answering that question. And the attorney says, wait a second. You are claiming that because of your injuries, you are no longer capable of working. And you also claim that you are no longer capable of working in the capacity in which you were working. So I'm entitled, the defense attorney argues, I'm entitled to know what you were earning at the time of this incident. I'm entitled to know what your status was within the company that you were working for, what your benefits were, and I want to know if you've earned anything since then. And you know what my client says? I don't care. I'm not telling you how much I was earning. I don't want that information public. I don't want anybody else to know. It's my business. That's private. Can my client actually do that? Can she bring a claim for lost earnings and lost future earnings and not allow the defense information that will help them evaluate whether or not she did in fact lose money and lost earning potential? The answer is no. If she wants to go ahead with a claim saying that the doctor was careless and because of his wrongdoing, she now is no longer able to work and no longer able to work in the way she was working before, then guess what? Then she has to disclose the information to the defense. She has to explain what she was earning at the time of the incident, as well as a few years leading up to the incident, because this way it will give the defense a timeline of her history, her earnings potential, and any benefits she was accumulating or accruing at that time. That's critically important to her damages claim to show that she lost money, lost financial earning potential, because of this injury. If my client refuses to answer those questions about lost earnings and lost earning potential, you know what will happen? At the end of her deposition, this examination before trial, the defense attorney will then ask the court formally, in writing, to take action. And you know what the defense will say? They'll say, Judge, I don't understand Mr. Oginski's client. She went ahead and brought a lawsuit against the doctor, claiming, among other things, that because of this injury, she can no longer work. Well, we have not been given the opportunity to learn the information, the details that will help us verify whether what she's saying is true. And because of that, because the client herself refuses to provide this information, refuses to provide her W-2 forms or her tax returns, as well as records from her employment, how can we go ahead and independently verify that what she's saying is true and accurate? We have no way to do that. And now, if we don't have a valid excuse to explain why we are not producing that information, you know what's going to happen? The judge is going to agree with them. And the judge is going to say, listen, since you have failed to produce this information and you are still claiming lost earnings and lost earning potential into the future, and you have failed to provide this information to the defense, I am now going to strike that claim from your lawsuit, which means your lawsuit will still go forward, but the claim of lost earnings is going to be out. You will no longer be able to prove that at the time of trial. And if you try and do it at the time of trial, I am going to make sure that you are prevented from getting any information, any testimony, any evidence about that out, and you will not be allowed to talk about that with any witness at the time of trial. Why? Because you did not give the defense an opportunity to explore your claim, to explore whether or not you had a valid claim here, and to get into details about how much it is that you claim you lost. Why do I share this information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases here in New York. You know, I recognize you're likely watching this because you wanted to join me in this gorgeous walk through the neighborhood today. Now, I realize you're likely watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.